So, in this video, we'll discuss another important subject under international law, and that is state succession and the very meaning of state succession and as it is defined by Oppenheim, J.G. Starr, and also under Vienna Convention of 1978. So, state succession means replacement of one state by another. In consequence, there is also change of legal rights and responsibilities towards international community in determining international relations. According to Oppenheim, a succession of international person or personality occurs when one or more international persons take place of another international person in consequence of certain changes in the latter's conditions. And to J.G. Starr, state succession means transmission of rights and obligations from states which are altered or lost their identity or other states or entities. Such alteration and loss of identity occurring primarily when complete or partial changes of sovereignty take place over portions of territory. The correct view on state succession would be to assume the views of Oppenheim. The Vienna Convention on State Succession of Treaties in 1978 expressed that state succession is substitution of one state by another over a fixed territory, and there is transfer of rights and responsibilities from one international legal person to another. And now we'll discuss the different modes of state succession, such as dismemberment, secession, annexion, merger, decolonization. So there are certain political, social, and other factors which gave rise to state succession. Political unrest, social and economic disturbances sometimes led to revolutionary changes in the internal affairs of a state which compelled express or impliedly interference by outside forces to bring complete or radical change in the existing state. These radical changes forced in existing state to the following situations which gave rise to state succession, and these are otherwise called as modes of state succession, such as dismemberment of an existing state, secession, annexion, merger, decolonization. Again, it could be said state succession could take place either voluntarily or by revolt. To analyze all these modes of state succession, it would be wise to discuss all of them under either universal state succession or partial state succession. So now we'll go to universal state succession. And in regard to universal state succession, when the international personality of the predecessor state is completely destroyed or absorbed by another international personality. This succession is termed as universal or total succession. And the best examples to cite are the annexion of South African Republic by United Kingdom in 1901 and Korea by Japan in 1910 and Austria by Germany in 1938, unification of Germany in 1995, merger of German Democratic Republic or East Germany with West Germany, the Federal Republic of Germany is another instance of universal state succession. Here there is complete creation and destruction of international legal personality of a state either voluntarily or through compulsory methods by mutual negotiation and agreement. The following states were formed, such as when United Kingdom granted independence to Myanmar and Sri Lanka in 1947, so the granting of independence to Morocco, Laos, Vietnam, and Cambodia by France, and also Netherlands granting independence to Indonesia. So also Italy's decision to grant independence to Somalia. So also when Bangladesh as a new state formed under revolt against Pakistan are the best example of universal state succession. So now we'll go to the other one, and that is partial state succession. And regarding partial state succession, that is when a part of the territory of a state is severed or separated from the parent state, and international legal personality is affected to that portion or to that extent of the territory affected of that state is called partial state succession. Partial state succession could be either by secession, annexion, conquest, or by dismemberment. The best examples to cite are when Estonia, Latvia, Lithuania, Turkmenistan, Ukraine, etc., and other 12 other new states were formed by dismemberment of Union of Soviet Socialist Republic in 1991. So also the new states of Slovenia and Croatia are formed from Czechoslovakia in 1992. So also Bosnia and Herzegovina from Yugoslavia in 1992, and also Macedonia from Greece in 1992 are the examples of secession as a way of partial state succession. So also the very annexion of Tibet in 1959 by China is also a form of partial state succession. So now we'll go to the very theories of state succession, and that is the universal succession theory, and the very exponent and propounder of this theory are Grotius, Pupendorff, Vattel, and they were the French international law jurist, and according to among them and according to them as the theories relating to universal succession theory. Grotius borrowed this concept from Roman law of succession regarding individuals into international law accordingly under universal state succession. There is complete transformation and change over public law, private law, public rights, public debts, and private debts, proof and draft, and battle followed these theoretical contentions of Grotius, but critics express that under succession there is only a transformation and change in respect to public law, public rights, and public debts. All other laws, rights, or debts relating as private in nature continues in spite changes of a state through either universal or partial succession until and unless so desired by the nationals or subjects of that state which is newly formed or created out of an existing state. And now we'll go to another important theory relating to state succession, and that is continuity theory, and which is propounded by Max Weber. So, Max Weber coined this theory. According to him, the substitution and continuation of some international legal person, so the new international legal person so replaced is not bound to discharge political obligation of the former state as it was expressed by Max Weber, who is the founder of constitutive theory of state succession. And now we'll go to another important theory relating to state succession is negative theory or clean slate theory, and it was propounded by Grosvenor. It is also known as clean state theory as it was propounded by Grosvenor, another international law jurist. According to him, there is no change in international personality of a state, whether by universal state succession or by partial state succession. There is no transfer of power from one international legal person to another. So there is no transformation of obligations and liabilities. To him, the new state acquires sovereignty in a clean state. And now we'll go to the laws relating to state succession and how these laws were developed in regards to state succession. So, one is the contribution of League of Nations in 1924, then the first Law Commission of United Nations Organization in 1949, the laws of succession of treaties of 1978, laws on succession in respect of rights and duties in 1983. So, in relation to that, we'll discuss the very development of law of state succession, there was the problem on devolution of rights and duties of the state newly formed out of an existing state. So also another problem to determine to the extent of such devolution in cases of universal and partial state succession as another crisis arises regarding the fixation of rule of law principles of equity, justice, good conscience, and reasonableness on the part of the newly created international legal personality, either under universal or partial state succession. Accordingly, the international community of states took certain steps for the formation and codification of laws on state succession. In consequence to the League of Nations in 1924 formed a committee on state succession of states and governments to formulate rules, but due to lack of uniformity, the task was left unfinished. After the formation of the United Nations in 1945, it constituted the first law commission and it entrusted the very task and formulation of laws and succession of states and governments to it in 1949. In 1967, it drafted the following laws. One is laws on succession of treaties. Second, laws on succession in respect of rights and duties. And the third one, laws and succession in respect of membership in international organization. Accordingly, in 1978, an international convention was adopted by majority in accepting the laws and succession of treaties. Subsequently, in 1983, the convention agreed by majority of states in adopting the laws and succession in respect of rights and duties. But the third one on succession in respect of membership into the international organization could not reach due to disagreement among majority member states. So presently, laws on state succession is confined to laws and treaties, and regarding the rights and obligation of a state, the newly formed out a former state. After all, laws and state succession is a political subject sometimes based on certain political consideration. So, after completing laws of state succession and how it developed from the initial period when League of Nations was formed after the First World War in 1920 under the initiative of the then late President of United States of America, Dr. Woodrow Wilson, and how it was remained unfinished the very task relating to laws of state succession. Then when United Nations was formed in 1949, the very law commission, which was considered as the first international law commission constituted by the United Nations in 1949, it drafted the very laws on state succession in 1967 and submitted it before the General Assembly of United Nations Organization, and the very conventions they were adopted regarding laws and succession of treaties 1978 also. The second, laws and succession in respect of rights and duties, it was adopted in 1983, but the third recommendation of the first law commission relating to laws and state succession regarding the membership of a state in relation to international organization was remained not adopted, and in our upcoming video we will discuss the very consequence of state succession.